Virginia judge found the filers of a federal lawsuit aiming to keep former President Donald Trump off the presidential ballot didn't have a valid argument.
Virginia court threw the case out without ever getting to the question of whether Section 3 applies to Donald Trump.
Section 3 of the 14th Amendment of the U.S. Constitution states those who have, quote, engaged in insurrection or rebellion are not allowed to hold government office. But a Virginia judge dismissed the case against whether this applies to former President Donald Trump. Here's why. First, there were procedural issues with the lawsuit itself. Just one example is one of the plaintiffs failing to record their email address, their phone number, and other missteps in the court process.
And they're filing all this stuff in a federal court, and they're not following the rules for the federal court.
But the bigger finding from the ruling is that the filers didn't have proper standing. Brad Jacob, Regent University's Associate Dean of the School of Law, said the plaintiffs needed to prove specific harm or injury from former President Trump staying on the presidential ballot, an argument that didn't succeed. This ruling keeps the former president on the ballot, but only because the filers didn't have proper standing in a federal court. It doesn't definitively answer in the eyes of Virginia's court system if the former president participated in or aided the insurrection at the Capitol 3 years ago.
Were the processes, were these hearings fair? Did they comport with due process? And I think there's a question there with regard to what Maine did, because if you look at the hearing, and she details this in the ruling, they heard from one fact witness, a law professor. She based her ruling on a lot of documents, but also YouTube clips, news reports, things that would never pass the bar in normal court. She's not a lawyer, by the way. It's a smartly written decision, clearly consulted with lawyers, but this is an unelected. She's chosen by the state legislature.
She's elected by the state legislature.
Elected by the legislature, but not democratically elected. Not a knock. That's just the way it's set up in Maine. And this hearing, look, it doesn't have to be a criminal trial. We don't have to have all the protections. But I think the argument you'll hear from opponents is, one, not up to the states to do this. This is why we have all different decisions from all different states. And two, the procedures were not up to snuff.
The speech done on January 6th that may or may not have influenced a crowd to storm the Capitol and break into the building and do all of what happened on January 6th, I think is a much weaker claim. And seeing how she's framed it here, emphasizing largely the word, speech, itself, the day, what happens on January 6th. I just think she's opening herself up and opening the state up and opening Democrats up to claims that this really, truly is politically motivated because a factual determination has not yet been made about the merit of the insurrection charge.
Standing regards the concept that you need to have a legal wrong between the individuals. Okay, so the party who is harmed is the party who can actually bring a cause of action. Individuals cannot bring a cause of action themselves against another person if they're not the individuals harmed. In general, the concept of standing says the party bringing the action has to be the one harmed, and that makes it so there's a legal issue in controversy, right, between the parties that can be resolved. If the parties here don't have a legal controversy, then there's nothing for the court to resolve in the situation. So it ascertains that there's an adversarial relationship. Now, standing has nothing to do with the actual merits of the case, whether a claim is valid or no. It just means whether one party is alleging harm themselves by the other party.